has also been associated with improving job opportunities. The majority of people in the United States access health coverage through their employer, yet by improving access to coverage that is not job-based, the ACA has afforded people the ability to leave or switch jobs with assurance that they won't lose the coverage. Moreover, the ACA created at least 240,000 jobs in the healthcare industry from 2014 to 2016, and women comprise the majority of healthcare workers. The chaos that would result from repealing the ACA would be felt particularly acutely by these employed in these jobs. 3, repealing the ACA would exacerbate existing barriers to reproductive and maternal health care services. According to the Centers for Disease Control and Prevention, pregnant people with COVID-19 have higher rates of hospitalization, admission to the intensive care unit, and mechanical ventilation. And alarmingly, Black pregnant women are disproportionately contracting COVID-19. Subsequently, there are concerns that the pandemic will exacerbate existing health inequities that have led to Black as well as American Indian and Alaska Native women dying from pregnancy-related complications at around 3 times the rate of white non-Hispanic women. A repeal of the ACA in its entirety would result in reduced access to pre- and postnatal care for as many as 13 million people in the individual market, because the individual and small group health plans would no longer be required to cover certain basic health care services known as essential health benefits, including maternity and newborn care. Eliminating the expanded Medicaid eligibility created under the ACA could also worsen the crisis, given that Medicaid expansion is associated with lower rates of maternal and infant mortality and covers 50% of births in the United States. Moreover, due to the many unknowns that remain regarding how COVID-19 affects pregnant people, some individuals may want to delay or forego pregnancy, necessitating access to comprehensive reproductive health services. The ACA requires most plans to cover birth control with no out-of-pocket costs. As a result, women have saved more than $1.4 billion a year in out-of-pocket costs on birth control pills. According to data from the National Women's Law Center, 61.4 million women currently have access to birth control as well as other preventive services, such as well women visits with no out-of-pocket costs, thanks to the ACA. Without requirements for those services to be covered, women would be forced to pay out-of-pocket or forego care if they could not afford to. Illustratively, without insurance coverage, birth control pills would cost a woman up to $600 per year, and an intrauterine device could cost about $1,000 out of pocket. Additionally, the pandemic has erected barriers that make it harder for women to access necessary and preventive care, both as a result of job losses and barriers to accessing care during the pandemic. As a result, women have already delayed care in recent months. A repeal of the ACA would only lead to further delays, given that plans would no longer be required to cover preventive screenings, mental and substance abuse services, rehabilitative services, and a host of other services. President Donald Trump and his conservative allies in the Senate are not only foregoing their responsibility to address the dueling health and economic crises, they're also rushing to install a new conservative justice on the Supreme Court who would tilt its balance in favor of striking down the ACA. With November oral arguments quickly approaching, this has increased the risk that the health care law will be repealed. Given the health benefits, protections against discrimination, and financial security that the ACA affords women, destroying that law would be immeasurably harmful to women at any time. But repealing the law in the midst of a global pandemic that has infected millions of Americans and killed more than 200,000 people in the United States would result in even more chaos and devastation. One of the newest groups of people with pre-existing conditions who are worried about losing or being able to afford coverage are the COVID long haulers. I'd like to read this article from Pew Stateline, written by Michael Olov, entitled "COVID-19 Long Haulers Worry About Coverage Costs." It reads, Andrea Sarisa has been through 3 gastroenterologists already and is now moving on to her 4th. She's seen an infectious disease specialist, a hematologist, a cardiologist, an ear, nose, and throat specialist, a psychiatrist, and an integrative doctor. She's seen an infectious disease specialist, a hematologist, a cardiologist. She's had an appointment coming up with a neuropsychologist and another one with a neurologist. She's had an endoscopy, a colonoscopy, a CT scan, a brain MRI, and so many blood tests. She said, "I feel like a human pincushion." She was planning a trip soon to an acupuncturist and has a referral for occupational therapy. Sarisa, a resident of Blanchburg, New Jersey, relayed this medical litany on day 164 of her COVID-19 ordeal. So far, she said, nothing much has helped. Before COVID-19, Sarisa was a healthy, active 46-year-old who managed a dental office by day and sang professionally by night, a woman who enjoyed yoga and jumped on Wave Runner any chance she got. Now, beset by a multitude of unshakable symptoms, she said COVID-19 has transformed her into a, quote, shell of what she was. All parts of her body are in rebellion. She has severe, persistent diarrhea, constant nausea, dizziness, paralyzing fatigue, piercing headaches, numbness in her limbs, blurry vision, ringing in her ears, and a loss of hearing. An unsurmountable and insurmountable deficit for a musician. She gets a rash on her face, finds light and sun painful on her eyes, a condition known as photophobia, and suddenly finds herself feeling uncomfortably cold for no reason. On top of all that is an alarming brain fog. Quote, "At some point in the conversation, she warned, I might lose my train of thought or forget words. When this will end, if it will end, none of these doctors and specialists can tell her, nor can anyone else, not at the federal Centers for Disease Control and Prevention, the National Institutes of Health, the World Health Organization, or any other major health organization. As a result, Sarisa has no idea what life holds for her." So-called long haulers like Sarisa pose policy questions that have yet to command much public attention, but daily become more pressing for those with lingering problems. Unable to work, will they have access to health insurance, especially if the Trump administration succeeds in overturning the Affordable Care Act? Will Medicaid be available to them? Will the federal government invest in research and treatments? Will they be eligible for disability benefits? Advocates say it's essential to begin grappling with these questions now as it becomes increasingly clear that for many, being ill with COVID-19 is not a transitory experience. As time goes on and our infection rates go up, the fallout is that an extraordinary large number of people who were previously healthy, working, and engaged in the economy will now become shadows of their former selves, said Diana Barrett, founder of Survivor Corps, a grassroots organization connecting those who have been infected with COVID-19. Barrett said it has 107,000 members. People are aging decades in the course of months, said Barrett, who is still experiencing symptoms months after her positive test. People in their 20s are suffering heart attacks and strokes months after their moderate or even mild COVID experiences. More attention needs to be paid to those with persistent, serious COVID-19 symptoms, said Dr. Amesh Adalia, an infectious disease doctor and senior scholar at the Johns Hopkins University Center for Health Security. Quote, "In this pandemic so far, we've thought mainly about the metrics of deaths and hospitalizations, but now we must think about people with long-haul symptoms," he said. How will this affect society as a whole? What happens if people don't go back to their former level of activity? For her part, Sarisa has no idea when or if she'll be able to return to work. She lost her employer-sponsored health care and recently got an Obamacare policy. But with uncertainty hanging over the ACA, she worries how long she'll have it. Mr. President, and I submit the rest of this article for submission.
Without objection. Senator from Nebraska.
Thank you, Mr. President. Senators have worked through the weekend, and the clock is obviously winding down later today. And tonight, after the final confirmation vote, Judge Amy Coney Barrett is going to become Justice Amy Coney Barrett. And for those of us who've been advocating for her, in my case, that's been since the summer of 2017, that is welcome news. She is an unparalleled nominee and will be a dazzling originalist on the Supreme Court. None of the baseless allegations that have been leveled against Judge Barrett have swayed any votes. Democrats didn't lay a glove on Judge Barrett in her confirmation hearings, and I think she ran circles around career politicians who want to outsource more lawmaking to unelected judges. Some folks are upset about that, and even though many of my male colleagues on the Judiciary Committee also complimented the Judiciary Committee chairman on a very well-run hearing, tragically, the minority leader seems that he's decided to make Dianne Feinstein a scapegoat for the unforgivable sin of being unwilling to turn more of Judge Barrett's hearings into another Michael Avenatti clown show. And I think that's just a painful moment in this institution's history, and it speaks volumes about how low some people are willing to sink in response to outside activists who would like to see bare-knuckled politics be the only thing that happens in the Senate. Judge Barrett's opponents know that they don't have the votes. They know that they don't actually have public support. They've seen the polling rise steadily week after week after week over the last month as the American public has gotten to know Judge Barrett better and learn more about her. They're more and more comfortable with her and less open to some of the sort of hyperbolic rhetoric that we've seen leveled against her. This is actually my fourth consecutive hour on the floor this morning. I've heard a series of speeches, and one of the things that's obvious is that there are a whole bunch of phrases that were written up. I don't know who wrote them up. I don't know how this process happens. But speech after speech after speech uses really similar phrasing to try to alarm and disturb and unsettle the American people. And I think the cynicism is just really tragic. I've heard now, I think, 4 speeches in a row implying that when Judge Barrett becomes Justice Barrett later tonight, that obviously means the end of health care in America. The last speech actually included this phrase, a vote for Amy Barrett is a vote to end health care. The speech said, a vote for Amy Coney Barrett is a vote to end health care. That isn't just preposterous, it is so destructive of the public good and of public trust. And I don't want this body to continue its decline, but I hope that next April, May, or June, when the Supreme Court rules and when Obamacare doesn't die, as no expert thinks this case is actually going to do, there's nobody no court watchers who really believe that the Supreme Court is going to end Obamacare this year. Severability is a pretty important legal concept that those of us who serve as public servants for a time should be helping the American people understand. And yet nobody on the other side of the aisle is talking about severability, even though everybody watching the court case knows that even if the opponents of Obamacare prevail in this case, that severability is what everyone expects will actually happen. And yet we hear again and again and again this rhetoric just motivated by the cynical desire to get people to vote out of fear and panic in the November elections. Nobody really believes this stuff. And so I hope the Democrats that are making these speeches, staying here all night to say again and again things like a vote for Amy Coney Barrett is a vote to end health care, please have the courage to come back next April, May, and June and say you lied to the American people. You were just trying to scare them into voting, and say what you were saying was BS. Whoever writes these outside talking points, it's really destructive, and the senators know better than to parrot this pap. So they're out of arguments, but they're not out of sound bites. And one of the things that's true in American life is that with freedom of speech, even if your sound bite is nonsense, you have the right to be wrong and you have the right to say it. So, given that we're going to be here all day, it's all over but the shouting, it seems like we don't have to play the same speeches on repeat over and over again. We can actually do two things, and I think that we should spend a little bit of time reviewing how we got here and a little bit of time talking about where we go next. First, we should explicitly name the Senate's most valuable player. And as somebody who is a junior member of this body, I don't want to cross Cocaine Mitch, the gentleman from Kentucky. But the truth of the matter is, the senator most responsible for the confirmation proceedings we have happening on the floor today is not from Kentucky. The senator most responsible for the fact that Amy Coney Barrett's going to be confirmed tonight, the senator most responsible for the confirmations of Neil Gorsuch and Brett Kavanaugh, is the former Democratic leader from Nevada, Senator Harry Reid. It was Senator Harry Reid that blew up the filibuster for judicial appointments in November of 2013, and the rest of how we got here is just a footnote on that history. Leader McConnell walked through some of this history on Friday and Saturday, how at every turn, from Robert Bork to Brett Kavanaugh, many progressives have, in an effort to try to secure policy outcomes in the Supreme Court, been escalating the confirmation wars. I won't repeat all of that history from Friday and Saturday here, but when Harry Reid went nuclear, he set the Senate on a path to this day. So here we are, with more than 200 federal judges confirmed in the last 4 years. Again, I've been on the floor for the last 4 hours, so I've heard multiple people lament the pace of judicial confirmations on the floor. Some people love it, some people hate it, but whether you got hate mail or you got love letters, your destination address should be Las Vegas, Nevada. There is simply no equivalent or comparable event in the confirmation escalation wars since they were created with the borking of Robert Bork in 1987. There's simply no comparable event with November of 2013 when Harry Reid decided to make this body simply majoritarian on confirmations. So where do we go next? It is no secret that some of my colleagues on the left are itching to blow up the legislative filibuster. It's a slightly better kept secret that a whole bunch of Democrats in the Senate think this is a really bad idea, but they're scared to death of the activist groups that have decided to go after Dianne Feinstein in the last 3 weeks as a sort of trial run to show what happens to people who would resist trying to turn the Senate into a simple majoritarian body. But I still want to at least compliment those folks in this body who've started to talk openly about their desire to blow up the filibuster for legislative process as well around here. I think it would be a very destructive thing to do, but I appreciate the people who are at least talking about it explicitly. I've been fighting about some of this with my friend Chris Coons. He is now open to blowing up the legislative filibuster, even though he was the leader of the Senate letter in, I think it was January of 2017, in defense of the filibuster. The position he had then when there was a new administration of a different party is the position that I had then, and it's still the position that I have now, and regardless of what party holds power around here in 2021 or 2025, I'm still going to be defending the Senate as a supermajoritarian body that tries to actually have a deliberative process. So I think that my friend Chris is wrong about being open to blowing up the legislative filibuster, but I don't think he's wrong because he's a Democrat. I think a whole bunch of Republicans were wrong about this issue in January of 2017, and so I fought with them as well. I got lots of angry calls and texts from Republican members of the House of Representatives in early 2017 for defending the legislative filibuster because the House and Senate are supposed to be different kinds of bodies. We have different purposes. And so my argument to Democrats now or in January is the same as the argument I made to Republicans in January of 2017, and that is that blowing up the filibuster would be to functionally kill the Senate. It would dramatically change not just this institution, but the structure of governance in our republic. Because without the filibuster, the Senate becomes just another majoritarian body, and we already have one of those. It's called the House of Representatives. The House and the Senate are supposed to have different complementary functions, and if we kill the filibuster in the Senate, we will have simple 51 to 49 votes, radically changing the direction of the country. We would see governance swings on a pendulum where big chunks of American life could be rewritten every 2 years with simple 51 to 49 or 49 to 51 majority changes and therefore new majority votes. We would become more like a parliamentary European system. It's a system that has some virtues, but we don't have that system, and our founders didn't pick that system on purpose. In an age of declining trust and increasing cynicism, the answer is surely not more instability. This would deplete, not replenish, our declining reservoirs of public trust. Killing the deliberative structure of the Senate would accelerate Congress's ongoing, slow, and bipartisan suicide, where fewer and fewer decisions are made by the people's elected representatives, and more decisions would be made by an unelected bureaucracy that the people back home that we represent in Nebraska or New York or Rhode Island or Virginia, the speeches that I've been hearing this morning, where those folks don't have any power to hire or fire people that work in the administrative state, and accountability of governance to the people means that we want the elected representatives to be making most of those decisions, not the unelectable bureaucracy. Even though lots of those people are well-meaning public servants, they're simply not accountable to the public. Senators like Joe Manchin, John Tester, Kyrsten Sinema would see diminished influence as the people of West Virginia, Montana, and Arizona got increasingly sidelined for even more representation of New York and California. Some of my colleagues apparently want to finish the work that Senator Reid began, but this would be to double down on the division, the cynicism, and the partisanship. And they would pretend that that is a day that they would never regret. But I think it would be really useful for more of the folks who are thinking now about whether they're either in favor of ending the legislative filibuster or whether they're too scared to stand up to the activist groups that are demanding they end the legislative filibuster. It would be useful for a lot more of them to go on the record with the things they say to me in private about their regrets about November of 2013. I've only been here since January of 2015, and I've had either 7 or 8 different Democrats currently serving in this body tell me how much they regret the vote that they took at Harry Reid's urging in 2013 to end the filibuster for confirmations to the judiciary. And I understand that a junior Republican senator from Nebraska doesn't have a lot of sway in the Democratic conference, but maybe they would listen to the quote of a different, more influential senator. The quote is this: "If the right of free and open debate is taken away from the minority party and the millions of Americans who ask us to be their voice, then I fear that the partisan atmosphere in Washington will be poisoned to the point where no one will be able to agree on anything. That does not serve anybody's best interest, and it certainly is not what the patriots who founded this democracy had in mind. We owe the people who sent us here much better than that. We owe them much, much more." Again, I'm going to repeat the quote. "If the right of free and open debate is taken away from the minority party and the millions of Americans who ask us to be their vote, then I fear the partisan atmosphere in Washington will be poisoned to the point where no one will be able to agree on anything. That does not serve anybody's interests, and it certainly is not what the patriots who founded this democracy had in mind. We owe the people who sent us here more than that. We owe them much, much more." Close quote. That quote was from the junior senator from Illinois in 2005, Senator Barack Obama, speaking passionately to this body about why it was different, why it is different, and why we have a stewardship obligation to defend the deliberative structure of the Senate. Senator, then President Obama was right then, he is right now, and I fear that he will sadly be right in the future if partisan tribalists decide to blow up the Senate and pack the Supreme Court. The debate over Amy Coney Barrett is over. We will be voting soon. But in the coming months, the debate for a critical piece of American governance will start. And I beg my colleagues to heed Senator Obama's advice. Protect America's structure of 3 branches of government. You lost this vote, but please don't burn down this institution. Again, you lost this vote under the rules that Harry Reid created in 2013. Please don't burn down this institution. Thank you, Mr. President.
President.
Senator from Rhode Island.
Good morning to you, and C-SPAN watchers everywhere. We're here in part because of a Supreme Court nomination, but we're here also because of a Supreme Court process that has turned foul in a considerable number of ways. And I'd like to spend the time that I have with you this morning walking through some of the history that got us there. With respect to the now standard Republican talking point that the only reason that we're here today in this partisan wrangle is because of Harry Reid, I would submit that the spectacle of procedural wreckage that surrounds all three of the last Supreme Court nominees completely belies any suggestion that Senator McConnell would have respected the filibuster of a Supreme Court judge. They've broken essentially every rule that got in their way. It didn't matter what it was, over and over again. And the idea that they would break every rule but that one simply makes no sense. So I can see that it's sort of a cute and clever argument to go back and point out that Harry Reid broke the effort to stonewall all of President Obama's appointees to the D.C. Circuit Court, which was what was going on at the time. But the rest of the wreckage belies that this would have been protected by Leader McConnell in the mad, headlong rush to load up the Supreme Court with nominees who have been through this very, very peculiar Supreme Court process. And to those who wonder why it is that we talk a lot about health care in the context of this nominee, look no further than the Republican Party platform that my colleagues supported, which says that Republican presidents will appoint judges to reverse the Obamacare cases. That is the language from their own party platform. So expect some skepticism about the sincerity of Republican expressions that they are shocked that we would try to tie the fate of the Affordable Care Act to this nominee when they have put that in their party platform. One of the unpleasant aspects of the process that I'm about to describe has been that the handoff to special interests of control over who gets appointed to the Supreme Court means that there's an audience for auditioning. And over again, we have seen judges audition to that audience in order to get onto that all-important Federalist Society list, or in the case of Judge Kavanaugh, excuse me, to get escorted by Leonard Leo, the operative of that operation, right around the list and onto its very top. Nobody auditioned like Brett Kavanaugh. But Judge Barrett made her own effort, and that was to make it very publicly clear that she disagreed with Justice Roberts, the swing vote who protected Obamacare. And that mattered because the outrage in the right wing that their Supreme Court, that they thought they had claimed, actually made one decision against their political interests, the sense of betrayal by Justice Roberts, that was very acute. And it was into that environment that Judge Barrett added her unsolicited opinion, just threw it out there, that Roberts was wrong, that the dissent had it right, and obviously that allows us, in fact, requires us to draw the logical conclusion that when she's the swing vote, she's going to go with the minority. So she telegraphed how she would rule in this matter. She became the nominee. It was on the Republican Party platform that she should reverse the Obamacare cases. How are we not supposed to notice this when you say this in all caps? So please, let's not pretend that we are making up a connection between this appointment and the persistent Republican attack on our present health care system. So the first thing that you have to understand in looking at the Republican judicial selection process is that we're now looking at three. We're now looking at three nominees that have come through this process. It began when I was in Munich on a trip with Senator McCain and Judiciary Chairman Graham. He wasn't the chairman then, I don't believe, but we'd gone to the Munich Security Conference together, and word came, in fact, I believe Senator Barrasso was there as well, who is now presiding. Word came that Justice Scalia had died on a hunting vacation and that there was a vacancy, and it became quickly evident that Merrick Garland, the chief judge of the D.C. Circuit Court of Appeals, a very widely respected judge, someone about whom Republican members of the Senate Judiciary Committee had said very good things in the past, presumably a consensus nominee, was likely to be the nominee of President Obama, a man who very often tried for consensus and very often was spurned. In this case, it did not take long for someone to decide that that was not going to happen, and indeed that no Obama nominee was going to be brought forward. It happened quickly, but not so quickly that a few members of the Senate said that they would, of course, meet with the nominee. That would be standard practice. Of course they would. But in the event, my recollection is that no one did. No Republican senator did. And that was a very sudden pivot by an entire body of people to go from normal process to something very new and abnormal. And in my experience, when a whole lot of people all pivot together to go from what is normal to something that is new and abnormal, you look for a reason. If you see all the branches blowing in one direction on a tree, you may be indoors. You may not actually be able to feel the wind blowing. But when you see all the branches lean, you can draw the reasonable conclusion, in fact, you can draw perhaps the only reasonable conclusion, that there is a wind blowing those branches. Which begs the question, what was the wind blowing all those branches to so immediately step out of the norms of the Senate? Not just one or two or 10, but as an entire caucus, and pivot to this new abnormal response to a presidential nominee. To me, that's a sign. That's a sign that political force is being applied, that a strong wind is blowing, and that all the branches have to lean in the same direction. And on we went through that process with very, very strong statements being made by judges about this newly found principle that during an election year, you don't confirm Supreme Court justices. They invented that new principle, highly convenient to that moment, but they described it as a principle. Here is Senator Daines in 2016. I don't think it's right to bring a nominee forward in an election year. He put it in about the strongest moral terms that one could use. He used terms of principle. He used the distinction between right and wrong. I don't think it's right to bring a nominee forward in an election year. Why? So that the people's voice, the people who've already begun voting, have their voice reflected. So that was probably, I don't know, maybe 8 months before the election. Here we are closer to 8 days before the election, and we're going through this process, and there's been this extraordinarily abrupt reversal of that supposed principle from 2016. I don't think it's right. If it's not right, why are we doing it right now? Suddenly, it's right in 2020. And Senator Daines wasn't alone. Mitch McConnell is the Senate floor orchestrator of all of this. Of course, he said, of course, the American people should have a say in the court's direction. That's why we can't take up Judge Garland now, because the American people should have their say months before the election. Here we are days before the election. Flipso, changeo. What could that mean? Senator Grassley, the American people shouldn't be denied a voice. That was then. This is now. Lindsey Graham, hold the tape. Hold my words against me, the chairman said. If an opening, here was his rule, if an opening comes in the last year of President Trump's term, we'll wait till the next election. Could you get clearer than that? If an opening comes in the last year of President Trump's term, we'll wait till the next election. Hold the tape. Ted Cruz, you don't do this in an election year. So what does it signal when people take a stand assertedly on principle that it wouldn't be right, Steve Daines, that you don't do this, Ted Cruz, that of course, the American people should have their say, Mitch McConnell and Chuck Grassley. What does it say when people take a stand on principle on one occasion, and then on the very next occasion, in the very next election, at the first opportunity, they completely reverse themselves on their supposed principle. Well, one possibility is that there has been a mini pandemic in the Senate of hypocrisy. That somehow there's a little germ here, and somebody brought hypocrisy into the Republican caucus, and everybody caught it. And they feel an unhealthy desire to go out and violate principles that they espoused on the previous occasion. That doesn't seem very credible to me. What seems more credible is that something is blowing the branches. That there is a force, a political force at work that causes Republican senators to take a firm stand on principle, albeit a novel one, a peculiar one, an unprecedented one, but in their words, a firm stand on principle in the 2016 election and exactly in the very next case in the 2020 election, completely reverse that supposed principle. My experience in politics is that when you see people forced to engage in hypocrisy in broad daylight, look for power in the shadows. So we began with the Garland-Gorsuch switcheroo based on this "you don't do this in an election year" principle. Then we went on to Judge Kavanaugh. And the narrative has developed on the Republican side that Judge Kavanaugh was treated very unfairly, as if no witness came forward to testify in the Senate Judiciary Committee that she had been assaulted by a young Brett Kavanaugh. I don't know what we were supposed to do with that information. Were we supposed to tell the good professor, "Go away, we don't want to hear from you"? Sorry, it's a little late. The chance that a person headed for the Supreme Court might have committed sexual assault is something we don't take at all seriously. We don't want to get to the bottom of it. We don't want to know. This was a woman who was willing to come and testify in front of all of America, subject herself to the hostile questioning of a professional prosecutor hired by the Republicans just for that occasion. And she stuck to her guns and, in my view, was credible. To this day, I still believe her. The nature of her testimony was very consistent with the testimony of sexual assault victims who have been through that kind of an ordeal. Do I know what happened? No. But she was a credible witness, and she was willing to come into the Senate Judiciary Committee and claim that Brett Kavanaugh assaulted her. Of course, we had to hear from her. Republicans want to blame Democrats for that, but seriously? Would you not have let her testify? Really? That does not seem very credible. So she came, she testified, she was credible, despite the right wing having launched their flying monkeys at her in such vehemence that she had to leave her house, hire private security, go into hiding. She nevertheless came, she nevertheless was credible. And all we asked for was an investigation to find out what had happened. Do our best to get to the bottom of it. It was going to be difficult because it happened years ago. But it would seem to me that we owed this institution and the Supreme Court our best effort. Did we get a best effort? No. We got a slipshod, truncated decision that to this day the FBI refuses to answer questions about. Why? Why not give Dr. Blasey Ford, why not give the American people, why not give the Supreme Court a best effort from the FBI to get to the bottom of whatever happened? There is every indication that the tip line that the FBI set up was never reviewed and followed up on. I've been a prosecutor. I've run the Attorney General's office in Rhode Island, which is the lead prosecutive office for the state. I've been the U.S. Attorney for Rhode Island, running federal prosecutions. The whole purpose of a tip line is to bring in evidence from the public, sort through it, because every tip line has bonkers evidence in it, but you sort through the chaff to see if there's any wheat there, if there's anything that needs to be looked into. It does not appear that the FBI looked into anything that came in through the tip line. It looks like the tip line, if you could imagine the comments box, it looks like they attached the comments box directly to the dumpster so that the tips went straight into the waste bin. I know of no tip that got followed up on. So once again, why? Why would the FBI allow itself to be associated with a truncated, incomplete investigation? Well, they said why. They said it was because they were not operating like an FBI when they do this. They're operating as the agent of the White House. They are operating at the White House's bidding when they are doing these confirmation investigations. They don't behave like the FBI then and follow their procedures. They do as they are told. That's a pretty strong clue, and once again a signal of powerful political forces at work to try to cram nominees, even very troubled ones, onto the Supreme Court. And then we come to Judge Barrett, who had to be the subject of this massive flipso-changeo of what was right for judicial nominees in an election year, and innumerable minor broken rules along the way. As I said, in all three of these recent nominations, there is a trail of procedural wreckage through the Senate. I don't think my colleagues hate Senate procedure. I don't think they get a form of malicious glee out of smashing Senate procedure. When you see a lot of procedural wreckage in the Senate, look for a motive. Look for a force. Look for a force. So 3 for 3. We've seen powerful signals of a motive force at work. And sure enough, when you look at the process itself, you see some real peculiarities. First of all, when these judges got selected, they had something in common. They all went through a process hosted at the Federalist Society and run by a person named Leonard Leo. The Wall Street Journal editorial page editor described this relationship as a subcontractor. The judicial selection got subcontracted out to this private organization and its operative. Subcontracted out. The White House counsel said this organization was insourced to the White House. Leonard Leo was put on temporary leave from the Federalist Society, like that's a big deal, to supervise the process. Can we just stop for a minute and accept that it is weird that any private organization would be made the subcontractor for the selection of Supreme Court justices? I don't care if it's the Girl Scouts of America. It's weird and it's wrong that a private organization should be the subcontractor for selecting judges. And it gets weirder and wronger when you see the big anonymous money pouring into that organization. The Washington Post took a pretty good, thorough look into this scheme, and they said that the whole scheme was $250 million worth of dark money. $250 million. They described it as a conservative activist behind-the-scenes campaign to remake the nation's courts. On whose behalf, one wonders, but you don't know, because the $250 million, the most of it is anonymous money, what we call around here dark money. So you have the last 3 nominees selected by a private organization secretively, which was also taking huge donations from anonymous donors. The whole scheme run up to $250 million, according to the Washington Post. That's a pretty big deal. And if you can't see that that is a recipe for corruption, you are wearing blinders. Because the idea that a private organization becomes designated to pick who's on the Supreme Court and then takes big anonymous donations is a prescription for disaster. But it does produce nominees, and at the end you get your selection. 1, 2, 3. Then those nominees get TV campaigns run for them. There's a big PR effort, a political effort. And that's run by something called the Judicial Crisis Network, which had as its operative Carrie Severino. Judicial Crisis Network gets boatloads of anonymous money also. So the same problem of a private organization, a secretive organization that takes boatloads of anonymous money, having a central role in campaigning for these nominees, that is also abnormal. This is new, this is peculiar, and this is wrong, in my view. By the way, when that Washington Post article came out, Leonard Leo got blown like an agent in a covert operation. And to protect the Federalist Society, he had to jump out, go do something else. So he went out to go do dark money-funded voter suppression. And guess who jumped into his role for Judge Barrett? Well, none other than Ms. Severino. And by the way, the Judicial Crisis Network's offices are next to the Federalist Society's offices. Same building, same floor. And how big is the money? Well, here's a little filing from the Judicial Crisis Network. From its IRS Form 990. Look at this. Got a contribution for $17.9 million. $17.9 million. Do we know who gave them $17.9 million to put on TV ads for a judicial nominee that had been selected by the dark money group behind the Federalist Society? We do not. We do not. But somebody wrote a $17 million check to support a PR campaign for a Supreme Court nominee. How do we know they didn't have business before the Supreme Court? How do we know that when they're anonymous? And by the way, they did it again. Somebody gave $17 million to push off Garland and help Gorsuch. And then another $17+ million gift came in for the troubled Kavanaugh nomination. Do we know that it's not the same donor? No, we don't. It could be the same donor, in which case somebody gave $35 million anonymously to influence the makeup of our United States Supreme Court. And they may have business before the court. There's a case called the Caperton case, in which the Supreme Court said you had a due process right not to have judges who'd had big money spent on their behalf to get the office rule in your case. This looks like a Caperton problem. $35 million spent by conceivably one donor who may very well have business before the court. Why would you do this? Why would you do this? Why would you ever allow judicial nominees to be selected this way, funded by dark money, anonymously, controlled by private, secretive organizations? Why would you do that? Why is that acceptable at all? I submit that were the shoe on the other foot, the other side would have its hair on fire about such a performance. The fact that this seems okay is yet another indication of the branches blowing in the wind here, because it is not okay by any objective or reasonable standard. The only thing that makes this okay is if that political force makes this okay in the same way they made it okay to reverse the 2016 principle on the very next occasion in 2020. When you see hypocrisy in the daylight, look for power in the shadows. And it doesn't end once their judges are selected and once the judges have their campaigns paid for by $17 million check writers. When they're on the court, guess who shows up in orchestrated choruses? Groups funded by dark money. In some cases, they are the litigating lawyer group. In some cases, they come on afterwards. That's what are called friends of the court, amici curiae, friends of the court. We had one case that I looked at about the Consumer Financial Protection Board where it turned out that a whole bunch of amici showed up. Amici curiae, friends of the court, a whole bunch of them. So I did this graphic in my brief that I filed, and it showed 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 briefs filed in that case by nominally separate groups, all funded by the same organization, Donors Trust. 8 out of 11 funded by the Bradley Foundation, and more overlapping donors throughout. This was just my work. Center for Media and Democracy went back and did an even more thorough drill down and came to even more astonishing conclusions about the overlap between the funding of these groups showing up in these orchestrated choruses. By the way, they don't tell the court that they're all funded by the same groups. They don't tell the other parties that they're all funded by the same groups. There's actually a disclosure in the briefing rule that says you're supposed to disclose who paid for your briefing. They use that to mean who paid for the printing of the brief. So you can take $1 million contribution from somebody, or who knows, $17 million contribution from somebody, and then pay a couple of $1,000 yourself to have the brief published and disclose nothing to the court, nothing to the parties about who's really behind these phony, baloney, trumped-up front group friends of the court. But they do provide an educating chorus for the judges and tell them how to rule. And by the way, the Center for Media Democracy showed that not only is the funding going to these legal groups, but the same funding is going over there to the Federalist Society to support this judicial selection operation. And from Judicial Crisis Network, you have the interchangeable Leonard Leo and Carrie Severino. This looks like a single scheme through which a small group of very secretive, big money donors capable of writing a $17 million check to help influence who's on the Supreme Court, get together and control the selection of Supreme Court justices, fund the PR campaigns and the TV advertisements for those Supreme Court justices, and then show up through front groups to pitch the justices on what they want from them. That is about as unhealthy a situation for a court as one could have. Again, we're like the frog, the alleged frog in the pot. It's gotten worse and worse. It has stunk more and more. But it happened kind of gradually, and we've, for some reason, have acted as if this is somehow normal. There is nothing normal about this. As a lawyer, I spent a good deal of my life in appellate courts. I've argued in the United States Supreme Court. I've argued in several circuit courts of appeal. I've argued over and over again before our state Supreme Court. To the extent that I had a specialty, it was appellate law. As the governor's legal counsel in Rhode Island, I was involved in picking judges for the state courts. On the Judiciary Committee, I've been involved in picking judges for the federal courts. Folks, this is weird. This is not right. Nobody behaves this way. Nobody farms out the selection of judges to private interest groups that don't disclose their donors and take up to $250 million into the scheme, according to the Washington Post. Weird enough that people feel the need to run TV ads for judicial nominees, but when they're taking a check for $17 million, 2 checks for $17 million from an anonymous donor, or maybe 2 anonymous donors, yeah, if you think that's weird, it's because it is. That shouldn't happen anywhere around a court. And if there's one thing that we are entitled to, there have been a lot of high-minded speeches about the importance of the judiciary and its independence and all of that. The most important standard that a court must meet is that it is not a pantomime court. A pantomime court in which the rituals of adjudication get acted out. People come to the bench wearing their robes, hear the arguments, render decisions, read the briefs. But at the end of the day, the decision is cooked by big special interest influence that insinuated its way into the court by controlling the selection of judges, by funding the PR campaigns for those judges, and by being the orchestrating force behind the amici curiae. And you might think that I'm being a little aggressive, suggesting that they're orchestrated. Well, remember this group, the Bradley Foundation, that I showed you from my Supreme Court checklist that funded 8 out of the 11 groups in that case? Here's a memo of a grant they're giving to something called the Judicial Education Project, which is a sister organization to that same Judicial Crisis Network. This is a little bit of a pea in a shell game, so forgive me, but they're directly related groups. And the staff recommendation says that at this highest of legal levels, it's a request for funding for amici curiae at the Supreme Court in several cases. It is very important to orchestrate high-caliber amicus efforts. Orchestrate. For Pete's sake, the secret funders use the word orchestrate themselves. So something is up. Something is not right. Something is rotten in Denmark. And if the American people are good enough to entrust us with the ability to answer their questions about this mess, we will answer their questions about this mess. I will tell you, I cannot get my questions answered. Not without gavels. Not in this Senate, not in these committees. But I think it matters if an individual wrote $35 million worth of checks to influence the makeup of our United States Supreme Court, to know whether they had business before the court, to know who they were, to be able to even do the Caperton analysis of whether some party's due process rights have been infringed by influence. So, in some respects, this is the end of things. This is the third of three nominees that have all had the same characteristics. They've been selected through this scheme. They've been campaigned for through this scheme. They've generated bizarre procedural behavior in this Senate. All three for three. It's like the triple trifecta. 3 judges, 3 characteristics. Selected, campaigned for, bizarre procedural anomalies. And when you see that kind of behavior, that's a lot of branches leaning the same way. And if that doesn't mean the wind is blowing, then give me a better explanation. But I think there's a foul wind blowing. And we need to find out who's behind it. And we need to find out what it means for our treasured Supreme Court. I'll close by saying that the results are already coming in. Even before Judge Barrett gets to the court, the results are already coming in from this effort. I did an article some time ago that we had pretty thoroughly fact-checked, red-teamed, and reviewed, that at the time said that there were 72 decisions by the United States Supreme Court under Chief Justice Roberts that had the following characteristics. 1, they were 5-4 decisions, the narrowest, barest majority. Ordinarily, a Supreme Court likes to see bigger majorities than that because it's conducive to the integrity and strength and credibility of the court. 72 5-4 decisions. They had an additional characteristic, not just 5-4, a partisan 5-4. No Democratic appointee joined the 5. So again, if you're an institutionalist, you look at that and you think, maybe that's not the court putting its best foot forward. That's an awful lot of partisan 5-4 decisions. And then the third characteristic is that you can identify quite readily in those cases a big Republican donor's interest, something that they would want by way of an outcome. And what we calculated at the time in that article is that the score in those 72 5-4 partisan decisions with a big Republican donor interest implicated is that the score was 72-0. Some pitching balls and calling balls and strikes. 72-0, that's a rout. And we've been tracking it since then. I put the number now at 80-0 because the article was written some time ago. So now we're at 80 partisan 5-4 cases in which a big Republican donor interest was implicated and in which 80-0, the big interests won. Now, some of these are pretty flagrant. I think Citizens United is going to go down in history as a disgraceful decision of the United States Supreme Court, sort of the political equivalent of Lochner. Shelby County, in which the court made up facts in order to strip a section out of the Voting Rights Act that in turn unleashed voter suppression laws across the states that had been held back by the pre-clearance provisions that the court summarily decided 5-4 that it didn't like any longer. Janus, the case that took down a 40-year-old precedent involving labor law, in which legal groups had an astonishing role. That case actually went through 4 cases along the way. It's a long saga. I won't burden this speech with that now. But the end of the day is that the lawyers for the labor movement walking up to the Supreme Court for argument that day knew perfectly well how the court was going to rule. That's not how courts should operate. Heller, the gun case, 5-4. A former Supreme Court justice had described the theory that Heller adopted as a fraud on the public. But Heller turned a fraud on the public into the law of the land. And guess what? The NRA is very active as a donor in these fights. The NRA was all over the Kavanaugh nomination in particular. So you had these flagrant decisions. I just mentioned those 4, but they're 80, so that leaves 76 others. And they're usually, often I should say, about power. They're often about moving power into corporations, expanding corporate power, allowing unlimited money into elections, allowing dark, anonymous, unlimited money to operate in elections. Who benefits from that? Entities with unlimited money and a motive to spend it, like, say, the fossil fuel industry. Intervening in elections, allowing bulk gerrymandering to proceed. Multiple courts had figured out how to stop that nefarious practice. It's actually not complicated when you're dealing with bulk gerrymandering, how to stop it. And over again, these bulk gerrymandering efforts to take an entire delegation and try to cook it so that it doesn't represent the popular vote in that state. Over and over again, courts had seen through that, figured out how to respond to it, until it got to the Supreme Court, and then 5-4, sorry, folks. We're not going to take an interest in that. Keep at it. Voter suppression. We'll tear down the preclearance provisions of the Voting Rights Act. All this election mischief that leans heavily to supporting the Republican side has been supported. Deregulation. If you're a big polluter, if you're a big donor, you probably don't like regulatory agencies. You probably would like to have some more freedom from regulatory agencies. And over again, these decisions try to hurt the independence and strength of regulatory agencies. Over and over. And then the last is the civil jury. My God, the civil jury is in the Constitution, for Pete's sake. We fought so hard over the civil jury that people didn't want to adopt the Constitution until there was a 7th Amendment that protected it in the Bill of Rights. Protecting the civil jury was in the Declaration of Independence. Interference with the civil jury by the Crown was a cause of war in the Revolutionary era. The civil jury is an institution of governance in this country. It is a big deal. And yet these supposed originalists on the court keep tearing down, whittling away at, diminishing and degrading the civil jury. Because guess what? If you are a big, powerful, well-funded, lobbyist-greased corporation or interest group, you can march around this place like a king, throwing your money around, getting everybody to bow and scrape for you, lobbyists smoothing the path for you. You can wander into the executive branch if you've got the right control and get your stooges appointed to the regulatory agencies. You can be powerful. You can get your way. And then you have to suffer the indignity of showing up in a courtroom where you have to be treated equally before the law, where what you say has to be put to the test of perjury, where you got to turn over your real documents and not phonied up position papers, where if you tamper with the jury, it's a crime. No wonder big special interests don't like civil juries. And no wonder this court, 5-4, over and over again, chops away at the institution of the civil jury. But don't tell me that you're being an institutionalist or an originalist when you're attacking an institution in the Constitution, in the Seventh Amendment, the Bill of Rights. That's the work that these 85-4 partisan decisions have been doing. It has been to turn this court more and more into the servant of big corporations. And guess what? Americans are paying attention. There was a poll a little while ago that asked whether the Supreme Court favors corporations more than people or people more than corporations. And the poll showed 49-7. 7 times as many Americans think that the Supreme Court views corporations more favorably than people than, say, the court views people more favorably than corporations. So something's out, something's up, a foul wind is blowing. There is way too much anonymous money in and around this court process. It is, by the way, at the same time, the only court that does not have a code of ethics in the federal system. When Judge Barrett is elevated from her circuit court to the Supreme Court, she will go from a court that has a judicial code of conduct to a court that does not. She will go from a court that requires transparent disclosure of gifts, travel, and hospitality to a court that requires less disclosure not only than circuit courts, requires less disclosure than cabinet officials, requires less disclosure than members of Congress. The highest court has the lowest standards for ethics and transparency. So to all of my colleagues who have given speeches about the integrity and value of the Supreme Court and our judicial branch, I hope you'll help us as we try to look at what on earth is exactly going on over there. Why amici curiae show up in court without disclosing who they're really there for. Why $17+ million checks are being written by anonymous individuals. What the relationship is between the $250 million that poured into Leonard Leo's effort is and who got chosen. What the expectations were of the people who spent $250 million to influence the makeup of the Supreme Court. And why the highest court has the lowest standards for ethics and for transparency. We are not in a good place right now with this court. The things that are happening are truly bizarre, unprecedented, bad enough that there should be dark money in elections. Dark money in judicial selection? Please defend that if you think that's right. Please defend that if you think that's right. If you think that big special interests should be able to write big anonymous checks and thereby gain a voice in the composition of the United States Supreme Court, please come and defend that proposition. Because I don't think you can. It has never been the case in the Supreme Court before. It has never been the case in the circuit courts of appeal before. It has never been the case in state Supreme Courts, in my experience. The dark money influence in and around the court is unprecedented, and it is wrong, and the American people are entitled to the truth about it. I see I've gone into my next speaker's time a bit, so I will yield the floor. If I may check a minute and see if the floor needs to be put into a quorum call. You're okay with that? Great. Then I will note the absence of a quorum.
Will clerk call the roll?
Mr. Alexander. Mr. President?
Senator from Wisconsin.
Mr. President,
Excuse me, we're in a quorum call.
Oh, I ask that the quorum call be vitiated.
Without objection.
Last Tuesday in my home state of Wisconsin, in-person early voting started. Over the past week, people have showed up to vote in record numbers, as they have across our entire country, because they want to make sure their voices are heard. Why? Because they know how high the stakes are for them in this election, an election that will determine our next president and control of the United States Senate, an election that is just 1 week away. My position on President Trump's Supreme Court nomination has been very clear since the tragic passing of Justice Ruth Bader Ginsburg. Voters across America should be allowed to cast their ballots first and have their votes counted before this Senate votes on a lifetime appointment to our nation's highest court. The people should be heard first, but it's clear that the Majority Leader and a majority of my colleagues on the other side of the aisle have no interest in listening to the people. That's why they are rushing and ramming President Trump's Supreme Court nomination forward just days before the election. This rigged and illegitimate process is wrong, and it follows a pattern of the Majority Leader and Senate Republicans abusing their power to break their own standards on Supreme Court nominations. Back in 2016, 8 months before the election, President Obama nominated Merrick Garland to a seat on the United States Supreme Court after the passing of Justice Antonin Scalia. Judge Garland is a highly experienced and qualified judge, and I have no doubt that had he been given the opportunity, he would have earned more than 60 votes in the United States Senate. But he was never given that opportunity because the Majority Leader decided to deny Judge Garland a hearing and a vote in the Senate. With the standards broken on the Garland nomination, the Majority Leader established a new one: no Supreme Court nominations by the Senate during an election year. Here we are in an election year. However, Majority Leader McConnell has broken his own rule and created yet another new one. Instead of applying the same standard that he imposed on President Obama with the Garland nomination in March of 2016, 8 months before an election, he created a new standard now for President Trump with his nomination of Judge Coney Barrett, made 39 days before an election. The Majority Leader is rushing President Trump's nominee forward with a Senate vote as people are voting as we stand 1 week before Election Day. So what's the rush? My home state is a national red zone for COVID-19. We are experiencing our worst outbreak of infections since the pandemic began, breaking records for new cases, hospitalizations, and deaths. Right now, people want action, support, and relief from Washington. The House passed the HEROES Act over 5 months ago. Was there a rush for the Senate majority to take action to confront the public health and economic crisis that has only gotten worse since then? No. This legislation has been sitting on the Majority Leader's desk since May, while businesses have closed, millions have lost their jobs, and hundreds of thousands of Americans have died. At the beginning of this month, the House once again passed an updated version of the HEROES Act to provide local communities and frontline healthcare workers with the support they need to stop the spread of this deadly virus. This legislation provides support to workers, families, schools, local governments, and small businesses. Was there a rush from the Senate majority to take action? No. Instead, the majority leader told the White House not to support this legislation because it would divide the other side of the aisle, and that they needed to focus on pushing this Supreme Court nomination forward before the election. So what's the hurry? My colleagues on the other side of the aisle have been trying to repeal the Affordable Care Act and take away people's health care since I came to the Senate back in 2013. I remember that vote to repeal the Affordable Care Act well. It was 2017, right here on the Senate floor, as President Trump and Senate Republicans sought to repeal the Affordable Care Act. Senator John McCain did something we are not seeing from the majority now with this illegitimate Supreme Court nomination process. Senator McCain stood by his principles and gave a thumbs down to repealing our nation's health care law. President Trump's response has been to try to do what the American people will not let this Senate do. In 2015, President Trump made clear his intentions with Supreme Court nominations when he said, and I quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare." In May of this year, he said, and I quote, "We want to terminate health care under Obamacare." The day after he announced his nomination of Judge Barrett, he tweeted that the Supreme Court invalidating the Affordable Care Act would be a big win for the USA. And just last week, he said he would like to terminate the Affordable Care Act. And we have a very good chance of doing it. He's right, but that's the problem. President Trump, with his Department of Justice, has supported a Republican lawsuit to overturn the Affordable Care Act completely. And on November 10th, 1 week after the election, the Trump-backed lawsuit will come before the United States Supreme Court. Judge Barrett has a record of criticizing and opposing the previous Supreme Court decisions that have upheld the Affordable Care Act. It's clear as day that the majority leader and Senate Republicans are driving a vote on the president's Supreme Court nomination in order to do what Trump wants: overturn the Affordable Care Act completely, terminate people's health care, and take away protections for people with pre-existing health conditions. Here's what's at stake if Judge Barrett does what Trump and Senate Republicans have been trying to do for years. Over 186,000 Wisconsinites have been infected with COVID-19, which could now be considered a pre-existing health condition. These people need the guaranteed protections that our Affordable Care Act provides, and they cannot afford to have the Supreme Court terminate their health care. If the Affordable Care Act is overturned, over 133 million Americans with pre-existing health conditions could stand to lose their guaranteed protections or be charged more, including more than 2 million Wisconsinites who have pre-existing health conditions. This issue is personal to me, as it is to so many others. When I was 9 years old, I got sick, really sick. I was in the hospital for 3 months. I eventually recovered, but when it came to health insurance, it was like I had a scarlet letter. My grandparents who had raised me couldn't find a policy that would cover me, not from any insurer and not at any price. All because I was a child who had been labeled with those terrifying words, pre-existing health condition. This is also personal for Chelsea from Seymour, Wisconsin, whose daughter Zoe was born with a congenital heart defect. Right now, thanks to the Affordable Care Act, Zoe is guaranteed access to coverage without being denied or charged more. Chelsea wrote to me, "I'm pleading with you as a mother to fight for the kids in Wisconsin with pre-existing health conditions that are counting on you to protect that right." Her fight is my fight today. No parent or grandparent should have to lie awake at night wondering if the health care they have today for themselves and their children and grandchildren will be there tomorrow. The fact is, more children have become uninsured in every year of the Trump administration, and striking down the Affordable Care Act would be the final devastating blow to children's health care. If President Trump succeeds with his lawsuit and gets a ruling from the person he is putting on the Supreme Court, Judge Barrett, an estimated 800,000 children would lose health care insurance. When Congress passed the Affordable Care Act over a decade ago, I led the effort in the House to include a provision that now allows young people to remain on their parents' health insurance until they turn 26. In Wisconsin, that means over 40,000 young adults in their 20s who have been infected with COVID-19. Many of these young people are likely already on their parents' health insurance plan or are receiving premium tax credits provided by the Affordable Care Act to lower costs and make health care more affordable. Recently, I heard the story of Amy from Neenah, Wisconsin. Her daughter is a nursing student at Marquette University in Milwaukee. She is on her mother's insurance plan, and they're worried that if the Senate shoves this nomination forward and Judge Barrett does what President Trump says she'll do, this young nursing student and future frontline healthcare worker will be kicked off her mother's insurance and lose access to her health care. Kirsten from Green Bay, Wisconsin, told me her story of being diagnosed with a very serious heart defect when she was just 11 days old. By the time she was 13 years old, she had undergone 17 angioplasties. Before the Affordable Care Act was passed, she struggled to keep insurance coverage, and she doesn't want to go back to the days when insurance companies wrote their own rules and could choose to deny people coverage, charge people more, or set annual or lifetime limits on people's health care. Kirsten, who is now 24 years old, said, quote, "Amy Coney Barrett has made it clear that she opposes the Affordable Care Act. With this nomination, the Republican Party is actively saying that our lives do not matter. If a decision is made on the Supreme Court nominee before the election, the American people are taken out of this selection." The message I've heard from Wisconsin has been clear. People want to be able to vote before the Senate votes. People want their voices to be heard. People want their health care protected, and they certainly don't want it taken away by President Trump or his nominee to the Supreme Court, during a deadly pandemic that has taken over 1,700 lives in my home state of Wisconsin and over 221,000 American lives. I would remind my friends on the other side of the aisle that for the women I have spoken about today, as well as all American women, if the Affordable Care Act is terminated, insurance companies could once again charge women more than men, and insurance companies could stop covering basic services like maternity care, cancer screenings, and contraception. The threat this nominee poses to women's health cannot be overstated. And the threat isn't limited to the Affordable Care Act. It extends beyond that. President Trump took office with a promise to nominate justices and judges who would overturn Roe versus Wade. He has nominated Judge Barrett, and her judicial record reveals a firm disagreement with the Supreme Court's 5 decades of established constitutional protections for women's reproductive rights. Let's all be honest with the American people. Since day one of this administration, a woman's constitutional right and freedom to make her own health care choices, including access to birth control, has been under assault. We know that what Amy Coney Barrett's personal views are, and I know that some of you support her for them. But let's be clear, I don't oppose her because of her personal. That is what is relevant here, because our Supreme Court plays an essential role in protecting and upholding civil rights and civil liberties, including the constitutional right for all women to make their own personal health care decisions and to have access to safe and legal reproductive care. The least this nominee's Senate supporters could do is be honest with the American people. We all know that if given the opportunity, a Justice Barrett would overturn Roe versus Wade. Don't pretend you don't know how she will come down on this issue. You should at least have the courage of your convictions and say to the people who are voting right now in this election that you support Amy Coney Barrett's nomination because you support overturning Roe versus Wade too. And you know she will help do it. Just as I don't trust this nominee to protect people's health care or women's reproductive rights, I have no faith in Judge Barrett to respect the progress that the LGBTQ community has worked so hard to achieve. Now, unlike President Trump's nominee, Justice Ruth Bader Ginsburg had a strong belief in equality for all, which was reflected in her life's work and in her judicial record on LGBTQ rights issues. In June, we again saw real progress in the Supreme Court with a landmark victory for justice and equality when the Supreme Court ruled 6-3 that workplace discrimination against LGBTQ people is wrong and our nation's civil rights laws forbid it. But we have a lot more work to do. LGBTQ people in many states can still be evicted from their homes or denied services simply because of who they are or who they love. The House passed the Bipartisan Equality Act to end this kind of discrimination well over a year ago. But that, too, has been in the Majority Leader's legislative graveyard and has not even received a vote in the Senate because he's afraid it just might pass. But here we are today moving forward on a Supreme Court nominee who I believe is a real threat to LGBTQ rights. Again, not because of her personal preference to oppose marriage equality, rather because she has openly and publicly defended the dissenters in the Supreme Court's landmark Obergefell case by questioning the court's role in even deciding that case. Earlier this month, two of the dissenters in that case that Judge Barrett defended previously, Justices Thomas and Alito, came out and attacked the court's 2015 decision, which declared that same-sex couples have a constitutional right to marry under the 14th Amendment guarantee to equal protection under the law. We just celebrated the 5-year anniversary of marriage equality becoming the law of the land. And I have no faith in Judge Barrett to protect this constitutional right. President Trump wants to overturn the Affordable Care Act completely and take away people's health care and protections for pre-existing health conditions in the middle of a deadly pandemic. This president wants to overturn Roe versus Wade and have the government take away reproductive freedoms for women. He has done nothing to move equality and fairness forward for the LGBTQ community and has worked to turn back the clock on hard-won progress. Judge Barrett has been nominated and will likely be confirmed by this Senate to do what President Trump wants. This nominee's complete and total unwillingness to show any independence from the president makes that clear to me. I believe it's wrong for Senate Republicans to rush this confirmation vote before the American people have voted and our next president and the next Senate have taken office. I oppose this illegitimate process, and I oppose Judge Barrett's confirmation for a lifetime appointment to our highest court because I do not have faith in her being a fair and independent Supreme Court justice for the American people. And with that, I yield.
Mr. Speaker.
Senator from New Mexico.
Thank you, Mr. Speaker, for the recognition today, and thank you very much for being here. Today, the Senate is gathered in the middle of an unprecedented pandemic. More than 220,000 Americans have died. Millions more have been infected. Millions more are out of work because of the resulting economic crisis. These are some of the hardest times to fall upon this nation in decades. People are hurting, they are scared, they are exhausted, and they are looking for help. Millions of Americans are also looking around asking how they can help in their communities. They're stepping up, whether it's as members of the essential workforce, as healthcare workers or by donating their time or resources to a charity or local food bank. We are seeing the best of this country. Here in the Senate, we too have the power to do something to help. On a much larger scale, we have the power and the duty. We could do something big to help beat this virus, to help people and businesses get back on their feet, get the kids back in school, to help make life easier for the millions who are struggling. And yes, the Senate is gathered in the middle of a pandemic. But we aren't gathered here by the majority leader to do anything to help the American people. We aren't gathered here to do the hard work, to negotiate, to compromise, and to pass an urgently needed COVID-19 relief package that Americans are clamoring for. No, instead, we're gathered here today to fast-track the confirmation of a far-right judge onto the United States Supreme Court. In the middle of a pandemic, 8 days before the conclusion of a presidential election, with tens of millions of ballots already cast. It is shameful. This body has truly lost its way. The American people are looking on in anger and disbelief as the Senate majority focuses on this nomination. Just 4 years after the majority, in no uncertain terms, said that the Senate should not consider a Supreme Court nominee 8 full months before the election. Yes, that's what Senate Majority Leader Mitch McConnell said. The Senate should not consider President Obama's Supreme Court nominee a full 8 months before the election. But now he says we should install President Trump's nominees 8 days before the election. How did we get here? Why would Republicans so flagrantly violate their own rules and violate the legitimacy of the court and the Senate for this nominee? To solve that mystery, we've actually got a clue. It's on the Supreme Court schedule. On November the 10th, the Supreme Court will hear oral arguments in a suit brought by Republican attorneys general and supported by the Trump administration to destroy the Affordable Care Act. 3 years after the Senate Republicans tried and failed to repeal the Affordable Care Act in Congress, they're now trying to terminate the law in the courts. Their relentless pursuit to destroy the nation's health care law knows no end. And they need to get their Supreme Court nominee onto the bench in time to hear their case. You've heard it many times over the last few weeks, but it bears repeating what's happening right now because it's stunning. Senate Republicans are rushing another far-right judge onto the bench days before the election, and all in the effort to cement a conservative majority on the Supreme Court to destroy the Affordable Care Act in the middle of a pandemic. This all taking place under the direction of a president who has stated the coronavirus pandemic affects virtually nobody. That's the president's direct quote, affects virtually nobody. That's what he's saying about the pandemic. Republicans want to rip away health care from the millions of people in the middle of a public health crisis that has killed more than 220,000 Americans. They want to take away protections from millions of people living with pre-existing conditions in the middle of a pandemic that has caused millions more Americans who have contracted COVID-19 to now have a new pre-existing condition. The president openly admits he wants the Supreme Court to do what Republicans in Congress couldn't do, and that is to demolish the ACA. It'll be so good if they end it. That's the president's quote. He said that on 60 Minutes. It will be so good if they end it, speaking about what the Supreme Court he wants them to do and what his Justice Department is arguing. And the President and Republicans in Congress don't have any plan to replace what they want to destroy. After all these years of trying to end the Affordable Care Act, including a 2-year period when the Republican Party held control in the House, Senate, and White House, they still don't have a replacement for the Affordable Care Act. If Republicans succeed, if this Supreme Court nominee joins an increasingly conservative court in striking down the ACA, the results would be catastrophic for my home state of New Mexico. The estimated 834,700 New Mexicans with pre-existing conditions would face higher costs, fewer benefits, and could have trouble finding coverage. Overturning the ACA would immediately end coverage for millions of Americans who became eligible for Medicaid through the Medicaid expansion. In fact, in my state of New Mexico, 250,000 people got coverage under that expansion. Seniors getting prescription drugs could no longer afford their medications. People like Jeannie, an Albuquerque-based senior, who told me recently, and I quote now, like many seniors, I take a medication that is so expensive that I would reach the donut hole every year. I can't afford to pay for that medication out of pocket," end quote. Rural hospitals, which are absolutely critical during this pandemic, could close their doors. As Dr. Val Wangler, the Chief Medical Officer of Rehoboth McKinley Healthcare Services, told me, and I quote here, "The Affordable Care Act is critical to the health of patients in New Mexico's rural communities. Threatening the health care coverage of our communities in the midst of the greatest public health crisis of our times is unconscionable," end quote. For Indian country and Native communities, ACA repeal would be absolutely devastating. I have heard firsthand accounts from tribal leaders, Native families, and healthcare providers about how the ACA has improved the healthcare landscape across Indian country, literally saving lives. The ACA has opened the doors for so many Native Americans to access the care they need, whether it's an unplanned medical emergency or routine wellness checkups and screenings. Access to quality health care is critical for Native communities which face disproportionate impacts from the COVID-19 pandemic. The federal government has a trust and treaty obligation to consult with tribes and to provide Native Americans health care. With this rushed, hypocritical process, Senate Republicans are violating our most sacred duties to Indian country. We know that the Supreme Court will rule on the fate of the Affordable Care Act. That much is certain. But what other cases might this court rule on in the near future? Or what other cases might Judge Barrett cast the deciding vote? Well, as you've heard me mention a few times now, we're in the middle of a presidential election, the most important election of our lifetimes. Facing an uncertain outcome at the polls, President Donald Trump has repeatedly sought to undermine the legitimacy of this election. He's lied about the safety of mail-in voting, despite the fact that he's a mail-in voter himself. He deliberately tried to weaken the Postal Service. And President Trump, along with members of this very body, are telegraphing that they want the Supreme Court, not voters, to decide this election. They want to sow enough doubt about the legitimacy of the democratic process that it has to go to the courts. and they want their hand-picked conservative judge to tip the scales for them. You don't get to choose the judge who decides your own case. That's not how we achieve true justice in a democracy. The core of our system is having an impartial judge. It has been shocking to watch as this president, aided and abetted by members of this very Senate, has been so overt about his desire to put a judge on the Supreme Court who will rule in his favor in any disputed election. That's a tactic of authoritarians, not a democracy. But in her confirmation hearing, Judge Barrett wouldn't even comment on whether a president should commit to the peaceful transfer of power, as this president has refused to do. She called that a political controversy. The peaceful transfer of power is not a political controversy. It is one of the most sacred tenets of our democracy. What else might Judge Barrett rule on in the coming years? No doubt cases concerning the most urgent existential crisis we are facing as a nation, climate change, cases to decide whether we'll let big polluters do whatever they want to our air, water, and planet. There is no denying the science of climate change. It is a real and present danger to the lives and livelihoods of people all across this nation and the world. My home state of New Mexico is in the bullseye with increasingly severe wildfires and droughts. This president is one of the few public figures left in this country who says he doesn't believe the scientists. You'd hope a nominee to the Supreme Court, the highest court in our land, wouldn't follow his lead. But Judge Barrett, again, wouldn't even comment on whether she believes climate change is real. She again said that was a political controversy. The only place climate change is a political controversy is within the White House and within the Republican Party. And the rest of us are paying the price while they decide whether or not to believe the overwhelming consensus of the scientific community, whether or not to believe their very eyes. There are so many other issues on which Justice Barrett would likely rule, including a woman's right to make her own health care decisions. A leading advocate for women's rights to reproductive health, Justice Ruth Bader Ginsburg would be replaced with a public advocate against Roe versus Wade. The nominee signed her name to statements against Roe that ran in full-page newspaper ads, undisclosed to the Senate. She signed joint public letters against Roe. This was also undisclosed to the Senate. She gave multiple speeches to organizations dedicated to overturning Roe, undisclosed to the Senate. In a law review article, she wrote that abortion was, and this is her quote, always immoral. And after promising for years only to nominate judges who will overturn Roe, Senate Republicans suddenly are shy about it. They suddenly don't have the courage of their convictions, and they won't let the public in on their true long-stated agenda, overturning Roe once and for all. There is so much else at stake in this fight, on voting rights, on worker rights, and so much more, all with real human consequences for the lives of people all across this country. Let's not lose sight of the real people who will be affected by this Republican march to overload the court with loyalists. With so much at stake, the American people deserve to have a say. It's that simple. So I urge my Republican colleagues to take a step back. Think about what you're doing. Think about the long-term damage you are doing to the legitimacy of the courts and to the faith of the American people that their voices are being heard. What's at stake is more than Justice Ginsburg's seat. It's the American people's seat. Mr. President, I yield the floor.
Mr. President.
Senator from New Hampshire.
Good morning, Mr. President, and I want to thank my colleague from New Mexico for his remarks just now. I rise today to join him and my other Democratic colleagues in opposing Amy Coney Barrett's nomination to the Supreme Court. Mr. President, I want to begin by acknowledging the nature of the moment that we are in right now. We are mere days from an election day, during an election period in which tens of millions of Americans have already voted. We are grappling with a global pandemic that has taken the lives of more than 220,000 Americans, and millions are out of work. Yet rather than focusing on providing the comprehensive relief that lives and livelihoods are depending on, Republicans have instead made pushing this nomination through their top priority. The American people deserve better. Mr. President, one of the most solemn responsibilities of a United States Senator is providing advice and consent with regard to a presidential Supreme Court nomination. This is a lifetime appointment to the highest court in our land, which will impact the lives of every single person in this country. The consequences of this nomination are far-reaching, and right now there is perhaps no more consequential issue than health care. The Trump administration and Republicans in Congress have been relentless in their attempts to sabotage our health care system, repeal the Affordable Care Act, and eliminate the health care protections that millions of people depend on. But for years, Republicans have failed legislatively to repeal this law. So now, instead, they've turned to the courts. President Trump said he wants to, quote, terminate, close quote, the Affordable Care Act, and has said that he would nominate judges who would do just that. 1 week after this election, just 9 days away, the Supreme Court will hear the lawsuit supported by the Trump administration to repeal the entire Affordable Care Act and its protections for people with pre-existing conditions. It's no secret that this is why Senate Republicans have rushed Judge Barrett's nomination through. For some of my colleagues, this nomination is a means to an end, a way to finally repeal the Affordable Care Act, a law that has helped so many. For the American people, however, this isn't a game. Mr. President, over the course of the last several weeks, people in my home state of New Hampshire and across the country have spoken out about what the repeal of this law would mean for them, just as they've spoken out each time that Republicans have tried to take coverage away. I recently heard from Michelle and Joe O'Leary of Atkinson, New Hampshire. Michelle and Joe's son, Matty, was diagnosed with a rare brain condition at the age of 4. Right now, Matty is doing well, but he requires a life-saving brain infusion treatment at the hospital for 4 to 6 hours every 2 weeks. His father said that the minute that they miss an infusion, Matty's health would begin to decline rapidly. Joe and Michelle said that on top of all of the challenges that their family experiences on a day-to-day basis, they still have to wake up each morning fearing the implications if the Supreme Court overturns the health care law, fearing what will happen if coverage is taken away and they can't access the treatment that their beloved Matty needs. Joe and Michelle shared the details of this deeply personal health care story in order to preserve health care for their son and millions of others. They shouldn't have to. No one in America should have to plead with their legislators to not take their health care away. No one should. But they do, in the wealthiest country on earth. Joe and Michelle are not alone. If Judge Barrett is confirmed and becomes the court's deciding vote to overturn the Affordable Care Act, an estimated 20 million Americans could lose their health care coverage. Making matters worse, in pushing this nomination through, my colleagues could undermine health care in the midst of a devastating pandemic. And just as we are learning that the long-term effects of this virus will likely mean that treatment for some will be ongoing for a lifetime, the Senate Republicans are moving to overturn the Affordable Care Act just when it is needed most. It is, Mr. President, unconscionable. Mr. President, potentially ripping away health care from millions of Americans is just one of the many things at stake. Women's reproductive freedom is at risk. President Trump has said that he will only nominate judges who would overturn Roe versus Wade. And Judge Barrett has repeatedly criticized this landmark ruling that provides women with the freedom to make their own health care decisions and control their own destinies. Be full citizens of the United States of America. Equality for LGBTQ Americans is also at risk. Just this month, 2 justices on the Supreme Court indicated their desire to overturn the decision in Obergefell v. Hodges, which delivered marriage equality to so many. Judge Barrett has previously defended the dissenting opinion in that case. And voting rights are at risk. Judge Barrett refused to acknowledge the fact that communities of color face disproportionate obstacles in voting. Nor would she acknowledge what every lawyer and really most high school students know, that voter intimidation is illegal and antithetical to our basic principles. Judge Barrett would not even give a straight answer when asked if presidents should commit to a peaceful transition of power, an essential element to our democracy, and one that we have held up as an example to the rest of the world throughout our history. And despite asserting that she is independent and not swayed by politics, Judge Barrett's refusal to acknowledge that climate change is real, after acknowledging other scientific facts, such as the infectious nature of COVID-19 and that cigarettes can cause cancer, reveals her alignment with and responsibility to a far-right climate change denying agenda. Mr. President, our founding documents gave us the flexibility and the tools to grow in our understanding of what individual freedom means and who is entitled to it. These tools have given us the power to create change and move forward, to unleash the talent and energy of previously marginalized citizens. Our country has prospered, thrived, and led as a result. But Judge Barrett's views and her judicial philosophy are not rooted in that belief. She instead would constrain individual liberty and empower corporations, and put the progress that so many have fought for at risk. Mr. President, Republicans have moved this nomination forward in contradiction of the rules that they themselves invented in 2016. Our society and our democracy relies on the idea that all sides of political debates will play by the same rules. That means when any faction loses, it does so knowing that it will have a fair chance in the next round. When that understanding is disrupted, it destabilizes our democracy and it sows confusion and chaos. My Senate Republicans colleagues' actions make it clear that they believe that the rules do not apply to them and that they do not care about destabilizing our democracy in this way. We should not vote on a Supreme Court nomination while an election is actually underway. For the first time in American history, voting on a Supreme Court nominee just days before Election Day. But my Republican colleagues have shown that they will stop at nothing to get this nominee through, no matter how many rules they break, and no matter how many Americans' rights are threatened. And they are doing so all while people across the country are pleading with us to come together to provide more support amid a public health and economic crisis. My Senate Republican colleagues' priorities are clear, and they are an outrage. Mr. President, I cannot support a lifetime nomination of an individual who puts the health care and basic civil rights of millions of Americans at risk. I will oppose Amy Coney Barrett's nomination to the Supreme Court, and I urge my colleagues to do the same. Thank you, Mr. President. I yield the floor.